Welcome back. We are following three major legal cases this afternoon, and we're joined by Sacramento Defense Attorney Mark Reichel to give us his legal analysis.
Mark, first let's talk about the Greyhound shooting suspect's arraignment. It was delayed Friday. He refused to leave his jail cell. How common is this, and what if he does it again tomorrow?
It's actually rare, but it does happen occasionally. I'm in the courtroom all the time, so it's not that uncommon, but like, again, it's a very, very few percentage. What the judge will do is do what's called an extraction order. And there's extraction teams. These are specialists, jailers that will go in, several of them, and extract the person, bring them back to answer the court in the courtroom. Because at some point, you do have to face the music, and you do have to appear in court. So at some point, the judge is going to issue what's called an extraction order if he refuses to come to court.
We'll see how it plays out tomorrow. Let's talk about a different case here, Mark. The family of the man accused of shooting and killing Stockton Fire Captain Max Fortuna is claiming self-defense, saying he thought he was being burglarized. Without getting into any of the specifics of the case, just generally speaking, how difficult is it to prove self-defense? Is it really considered a winning legal strategy?
You know, it always depends on the facts. And what you really do, you ask a jury to put themselves in the defendant's place. Of course, the prosecution is going to say, not that many people shoot at a firefighter, okay? So they're going to ask, the defense is going to say to the jury, what would you have done? It's reasonable what he did, correct? It's reasonable. And the prosecution is going to say, I doubt that any of you jurors would ever, under any circumstance, believe this is something you would do, or that we would consider it reasonable afterwards. So that's really what it comes down to.
All right, let's talk Scott Peterson now. A juror did not disclose she was a crime victim, and now he wants a new trial. His family says the jury never even heard evidence that could set him free. How common is it for a judge to grant a new trial, and what do you think his chances are?
You know, it's really kind of uncommon. We want finality. We want fairness, but we want finality for the victim's family, for the witnesses, for the jurors, for everyone. So we really do everything we can to make the first trial as fair as possible. They're really going to take a final analysis and say, look, was this a fair trial? Is it something we can live historically in the legal community with? And if not, there is a small chance, although I doubt it. I don't want to predict things here because your prediction on television is always for eternity. I don't think it's going to be granted.
All right. Well, Mark Reichel, thanks so much. We know you rushed in to talk with us after a court appearance this afternoon. We certainly appreciate it.
I appreciate you waiting for me.